Good day everyone, I am Gilbert Intia, and in this video, I will be discussing the Section 1 of the Essential Requisites of Contracts from Article 1325 up to Article 1331. So without a further ado, let's start. Article 1325. Unless it appears otherwise, business advertisements of things for sale are not definite offers but mere invitations to make an offer. Article 1325 is mostly about business advertisements. It says here that business advertisements of things for sale are not definite offers but are a mere invitation to people to make an offer. Yung mga nakikita nating ads sa kung saan man, they are not considered as definite offers unless it appears otherwise. So, what does it mean? If we will be asked if a specific business advertisement is a definite offer or not, the answer is it depends. If you're wondering why, it is because if the said business advertisement contains all the specific particulars needed in a contract, then it is really a definite offer. Pero if the business advertisement does not appear to be a definite offer, kumbaga inadequate or kulang yung information given, then it is just a mere invitation to people to make an offer. So to better understand this, I have prepared some examples for everyone.
A for sale, 1,000 square meters lot at Green Plains Village, Quezon City for 5 million pesos tel. Number 817-12-84. B for sale, 1,000 square meters lot at Green Plains Village, Quezon City located at the corner of Geronimo and Magdalene Streets for 5 million pesos cash. Tel. Number 817-12-84. C for sale, 100 square meter lot, with two-story house located at 123 XQC Street, Malad, Manila for 10 million pesos cash. D for sale, 100 square meter lot, at 10M-20M at 123 XQC Street, Malad, Manila.
Among these business advertisements, which do you think is a definite offer? If your answer is B and C, then you are correct. Kung titignan natin yung letter B and C, it contains all the specific particulars na kailangan sa contract. In letter B and C, the exact location nung binibentang lot is stated as well as the exact price and its mode of payment. So if the buyer will accept this offer, it will produce a perfected contract. Yung A and D, they are considered as just mere invitation to people to make an offer. Kung titingnan natin yung letter A and D, may mga important details pa na hindi nilagay sa ads. Like for example, is in letter A, the exact location of the lot isn't stated in the ads. And yung price na 5 million peso, hindi sinabi kung in cash or installments and etc. Sa letter D naman, the advertisement does not stated na may kasama na palang two-story house yung lot and yung price is hindi din exact. So basically, it is not a definite offer but just a mere invitation to people to make an offer. Article 1326. Advertisements for bidders are simply invitations to make proposals, and the advertiser is not bound to accept the highest or lowest bidder unless the contrary appears. This Article 1326 naman po is about advertisements for bidders. It says here that advertisements for bidders generally are not definite offers but are just simply an invitation to people to make proposals, because in reality, the bidders themselves are the one making the offers, and the advertisers are just inviting bidders to make proposal. The advertisers as well are free to accept or reject the offer from the bidders, and para magkaroon ng contract, the advertisers needs to accept the offer from one of the bidders. So, to sum it up, sinasabi sa article na to na most of the advertisements are simply invitations to make an offer and are not an offer itself because not all the necessary terms or details can fit in an advertisement unless the contrary appears, just like in Article 1325, wherein an advertisement contains all the specific particulars needed for a contract. Pero ang general rule is that advertisements for bidders are just invitation. Article 1327. The following cannot give consent to a contract. Number 1, unemancipated minors. Number 2, insane or demented persons, and deaf mutes who do not know how to write. Article 1327 talks about the capacity of a person to enter into a contract and to give a consent to a contract. It is stated here in Article 1327 that unemancipated minors, insane or demented persons, and deaf mutes who do not know how to write cannot give consent to a contract. Sabi dito, a contract entered into where one of these party is incapable of giving consent to a contract is voidable. These voidable contracts are still valid contract unless it is annulled by proper action in court. First is yung unemancipated minors. Unemancipated minors are those persons who have not yet reached the age of majority, which is 18 years old. They are presumed na hindi pa nila kayang mag-decide para sa sarili nila since they are still young and they don't have that much experience in life to make an intelligible decision. Hence, parental authority is still needed. Second is yung insane or demented persons. Itong insane or demented persons, they cannot give consent to a contract because in their case, they are detached from reality and they don't know what they are doing, kaya they cannot enter into valid contracts unless they acted during their lucid interval. Ito kasing mga insane or demented persons, not all the time naman silang ganyan. There are times na nasa tamang pag-iisip din sila and if so happens, they entered into a contract during lucid interval, so they have the capacity to give consent, then yung contract will be valid. Yung third naman, those deaf mutes who do not know how to write. They cannot give consent to a contract since they are not capable of understanding things unless itong deaf mutes na to can read and write. Then masasabi nating they are capable of understanding. So in this case, the contract entered into will be valid. The reasons for disqualifying these persons or making them incapable of giving consent is dahil na rin sa situation nila. Because these unemancipated minors, insane or demented, and yung deaf mutes who do not know how to write are vulnerable to fraud since they are not capable of understanding things and they can be easily taken advantage by anybody. Pero itong mga contract who are entered into by person who are incapacitated to give consent are voidable, meaning to say it is valid until annulled. Actually, there are two kinds of voidable contracts. First is yung contract where one party is incapacitated to give consent, which is ito yung diniscuss natin ngayon lang. And yung second naman is if the consent of one party is vitiated, which will be further discussed sa mga susunod pang articles. Article 1328. Contracts entered into during a lucid interval are valid. Contracts agreed to in a state of drunkenness or during a hypnotic spell are voidable. As I've said earlier in Article 1327, insane or demented persons cannot give consent to a contract unless they acted during lucid interval. Then the contract will be valid. So what does lucid interval means? Lucid interval is a temporary period of sanity. This is a period where these insane or demented persons are in their right mind or nasa tamang katinoan sila. If an insane or demented person enter into a contract during lucid interval, considered valid yung kontrata. As for drunkenness and hypnotic spell naman, contracts agreed to under these states are voidable. Why? It is because those who are in the state of drunkenness temporarily results in a complete loss of understanding and therefore be equivalent to temporary insanity. 'Di ba, pag nalalasing ang tao, halos wala sila sa katinuan nila and they don't know what they are doing, and when they woke up, they don't seem to remember what happened and some even regret what they have done. Also, during a hypnotic spell induced by drugs or by deliberate hypnotism and therefore one party is incapable of giving intelligent consent, contracts agreed to in all these states are valid and voidable and it can be annulled by proper action in court. Article 1329. The incapacity declared in Article 1327 is subject to the modifications determined by law and is understood to be without prejudice to special disqualifications established in the laws. Here in Article 1329, it is stated that those declared incapacitated, such as the unemancipated minors, insane or demented persons, and deaf-mutes who do not know how to write, are subjected to the modifications determined by law. Kasi there are instances naman na although these persons are incapacitated, they can still give valid consent and enter into a contract. Like for example, when the contract involves the sale and delivery of necessaries such as food to a minor, then kailangan magbayad ni minor and it is considered valid. And if yung contract involves insurances like life and health insurance and etc., then the contract will be valid as well. And the contract will also be considered valid if entered into through guardian or legal representative. A contract is valid as well even magsinungaling yung isang minor regarding sa age niya. And sinabi niya na yung age niya is above 18 and naniwala naman yung other party, then valid pa din yung contract. Pero dito sa Article 1329, there are still other disqualifications provided by law that will incapacitate a person to give consent. And sino-sino nga ba tong mga to? These are those persons suffering the penalty of civil interdiction, hospitalized lepers, prodigals, deaf and dumb who are unable to read and write, those who are of unsound mind even during lucid intervals, and those persons by any reasons cannot take care of themselves and are easy to be taken advantage of by anybody. Those persons I've just mentioned are considered incompetent and be placed under guardianship, and any contract they entered into is valid and voidable at the same time. Article 1330. A contract where consent is given through mistake, violence, intimidation, undue influence, or fraud is voidable. So yung Article 1330, actually this is what I'm talking about earlier. In Article 1327, I have mentioned the two kinds of voidable contracts. Yung first is one where one of the parties is incapacitated to give consent. Ito yung na-discuss natin kanina. And yung second naman is here in Article 1330, wherein the consent of one of the party is vitiated. In order for a consent may be valid for purposes of a contract, it must be, first, intelligent. In a way na yung magbibigay ng consent must have the capacity to act. Second, it must be free and voluntary. Kumbaga, kusang loob at bukal sa kalooban ng person yung ibibigay niyang consent. and not because the person was threatened or coerced or nag-undergo through violence or intimidation. And last, it must be conscious or spontaneous. Meaning to say, walang vitiation sa consent, and the consent itself was given not by mistake or by reason of fraud or anything. Also here in Article 1330, the vices of consent are enumerated. Ano nga ba itong mga bagay na to na nakakapag-influence sa isang person to give his or her consent? So number 1 is error or mistake, 2, violence or force, 3, intimidation or threat, 4, undue influence, and 5, fraud or deceit. Itong mistake or error and yung fraud or deceit, ang naapektuhan dito is yung intellect ng tao. While yung violence or force, intimidation or threat, and undue influence, ang naapektuhan naman is yung will natin. Because whenever a person gives his consent, it should be intelligent and must have the capacity to act. And it also must be free and voluntary and spontaneous, so dapat walang vitiation na nangyari. Kasi dito sa mistake and fraud, it affects our cognition, yung pag-iisip natin. Kasi diba, naloko tayo, nauto tayo, nagkamali tayo sa pag-alam kung alin yung totoo, kaya nagbigay tayo ng consent. Itong violence, intimidation, and undue influence naman, it affects our will. Come to think of it, if someone uses force against you, you were physically coerced, binugbog ka, sinaktan ka, or pwede ding you were threatened by someone, and sa undue influence naman, someone superior to you taken advantage of his power. Diba? It really affects our will. So basically, oo na lang agad tayo since natatakot tayo sa kung ano pang pwedeng mangyari sa atin. And if any of these are present upon giving the consent, then the contract is voidable. Itong sinasabi kong voidable contract is still valid and binding unless annulled, and it can be annulled through proper action in court. Article 1331. In order that mistake may invalidate consent, it should refer to the substance of the thing which is the object of the contract, or to those conditions which have principally moved one or both parties to enter into the contract. Mistake as to the identity or qualifications of one of the parties will vitiate consent only when such identity or qualifications have been the principal cause of the contract. A simple mistake of account shall give rise to its correction. This article is pretty long, but it mostly just answered the question, when does an error or mistake vitiates consent? Kailan ba natin masasabi na sufficient yung mistake or error na yon to vitiate consent? First, let us define mistake or error. Mistake or error is the false notion of a thing or a fact material to the contract. So here in Article 1331, it is stated here the nature of a mistake to vitiate a consent. So the first one, a mistake must be a fact or of law, and it may arise from ignorance or lack of knowledge. Next, the mistake should be a substantial mistake of fact where the other party would not have given his consent if he had known the mistake. And last, the mistake may either be unilateral, where only one was mistaken about a material fact, or bilateral, in which both parties are in error. So in order for a mistake to vitiate consent, it must refer to the following. Number 1, the substance of the thing or the objects of the contract. So dito, the mistake or error is the object of the contract. Like for example, Valkyrie is buying from Pokimane an earbuds, but Pokimane is selling earbuds cases. Saikuno is buying from Corpse a breeding cow, but Corpse is selling a barren cow. If Valkyrie have known na earbuds cases pala yung binibenta ni Pokimane and not an actual earbud, then Valkyrie would not have entered into that contract kasi ano nga namang gagawin ni Valkyrie sa earbuds cases wala naman siyang earbuds. Same case with Saikuno. he would not have entered into that contract as well if he had known na barren cow pala yung object and not a breeding cow. So in this case, the mistake is the object of the contract. Number 2. Conditions which have principally moved one or both parties to enter into the contract. Dito naman, the mistake is the conditions in the contract. Like for example, Leslie is selling her townhouse for 2 million cash, but Bretman is buying the townhouse thinking that the price is payable in installments. So dito naman, Bretman was mistaken in thinking that the townhouse can be paid through installment, and he would not have entered into that contract if he only knew that the townhouse must be paid in cash. And last, number 3, the identity or qualifications of one of the parties. So sa pangatlo, the mistake here is the identity or qualification of one of the parties. Example, Jeremy donated his car to Toast. Jeremy thought that Toast was his half-brother. It turned out that Toast is not related to Jeremy. In this case, the mistake is on the identity or qualifications, since it was the principal reason why Jeremy donated his car to Toast. If he only had known that Toast is not actually his half-brother, he would not have donated his car. Sa last sentence ng Article 1331, it is stated that a simple mistake of account shall give rise to its correction. Actually, there are two effects of mistake of account. First is where mistake is simple. It is when a simple mistake of account or calculation does not avoid a contract because it does not affect its essential requisites. For example, Wendy sold to Hafu a parcel of land with an area of 567 square meters at 415 per square meter. In the document of sale, the purchase price stated is 285,305 pesos when it should be 235,305 pesos. The mistake here will not make the contract voidable kasi the mistake is merely an error in computation and hindi naman siya ganong kasubstantial para i-annul yung contract. So, what we're gonna do is itatama lang natin yung mistake by putting the true amount. Yung second effect of mistake of account naman is where mistake grows. It is where the mistake was so gross that it was clearly apparent to one party and imposibleng hindi niya mapansin yon. For example, Wendy sold to Hafu a parcel of land for 235,305 pesos, stated as having an area of 567 square meters but with an actual area of only 467 square meters. So in this case, Hafu has the right to ask for the rescission or cancellation of the contract, and Wendy will be held liable for the mistake kasi parang fraud na ang nangyari dito. Hafu expected the land to be 567 square meters as it was stated in the contract, pero yung actual measure lang pala ng land is 467. So in this case, Wendy cannot avoid liability on the ground of mistake in computation. Before I end the Article 1331, I just want to mention the mistake or error which could have been avoided by the parties involved. Kumbaga, kung binuswisi lang sana nila or nag-exercise sana sila ng ordinary diligence, maiiwasan sana yung mistake, or pwede ding the mistake is so obvious that nobody could have made it, then it will not invalidate consent. Itong mga mistake na diniscuss natin, these are just a mistake of fact and not a mistake of law. The concept of mistake of law is iba sa diniscuss natin because sa mistake of law, basically involved na dito yung law, and ignorance of the law excuses no one. And these things will be discussed by the next reporters. And that's all for Article 1325 to Article 1331. I hope you had a great day today. Bye!